This is Lecture 16, the Doctrine of Equivalents, Part 3. The agenda for this lecture is to look at prior art limits on the Doctrine of Equivalents, another important set of limitations on the doctrine. The disclosed but unclaimed subject matter doctrine, sometimes known as the dedication doctrine. Again, a limit on the Doctrine of Equivalents. Doesn't come up all that often, but it is an important one. And then talk a little bit about the Doctrine of Equivalence and 112F, or means plus function claims, how that works, and then a brief discussion about the reverse Doctrine of Equivalence and what role, if any, that might play in modern patent law. Prior art limits on the Doctrine of Equivalence. So what we're doing today, as a general matter, is talking about more limitations on the Doctrine of Equivalence. And again, putting this in context, you'll recall that the Doctrine of Equivalence has been controversial from the outset, with the idea being, the main objection being that it undermines the notice function of patents by allowing patentees to assert the scope of their patents beyond what their claims actually say. That is, giving a range of equivalence surrounding each set of patents. As you'll recall from Warner-Jenkinson, since Warner-Jenkinson, the Federal Circuit in particular has worked quite hard to find a variety of limits, almost all of them limits as a matter of law, on the scope of the Doctrine of Equivalence. And the limits we're going to talk about today are important components of those. And one of the most important, and we've discussed this a little bit already, is the prior art limits the Doctrine of Equivalence. And the basic rule here, I'll get to the bottom line right away, is that you can't assert a range of equivalence for your patent claim that would cover something that's already in the prior art. And so let's see how that works in practice. So consider this. Your original unamended claim, so there's no prosecution history estoppel issue, is a fastening system comprising a square-headed stainless steel bolt and a corresponding nut. The prior art has brass hex-headed bolts and nuts. Right? So the prior art includes similar but obviously not the same things. Let's set aside issues of validity. This might be an obvious claim, but we'll set that aside at this point. And the question that we're dealing with here is, can you get Doctrine of Equivalence coverage of brass hex-headed bolts and nuts? Right? And I think the answer to that seems pretty clear. You shouldn't. Right? You should not be able to achieve with the Doctrine of Equivalence that which you could not get by directly claiming it. And since you couldn't actually claim brass hex-headed bolts and nuts and have a valid patent, why? Well, it's in the prior art. You'd fail under Section 102. You shouldn't be able to use the Doctrine of Equivalence to get that coverage anyway. So that's the basic issue here. And it gets more complicated when you consider the second example I have listed there, which is brass square-headed bolts and nuts. Right? And the issue there is that is not in the prior art. Right? So that particular asserted equivalent is actually not in the prior art exactly, but it's very close to what's in the prior art. And so that's where we get the question, the more complicated question. And let's look at a case. So the main case here is Wilson Sporting Goods, which is actually a 1990 case. And Wilson Sporting Goods deals with patents for golf balls. As an aside, you'd be shocked at how many patents for golf ball designs there are. Golf balls are obviously a very high-tech area of innovation, one that has a lot of regulatory, from the golf rules of golf, has a lot of regulatory influence that has been changing around, a lot of technological advances, and so for that reason there's a whole range of patents related to golf balls. In particular, the Wilson Sporting Goods patent is about dimple patterns on golf balls. Right? And the Wilson Sporting Goods basic invention was a golf ball dimple pattern that required 6 what they called great circle paths, so paths that completely encircled the ball, that wouldn't intersect at all, and were and also didn't go into any of the dimples. Right? And that was the basic invention. You can see figures 1, 2, and 3 up there basically show how that would work, right? How there would be great circle paths that wouldn't intersect with either each other or with any of the dimples. The prior art had patterns with 6 great circle paths which had intersections, right, that actually would cross through some of either they would intersect with each other or they would cross through some of the dimples as part of the path that the pattern made around the ball, right? And so there was a bunch of prior art, as you might expect. It's a crowded field. The accused device here were 6 great circles with 60 intersections, right? So you've got the claim says 6 great circle paths, no intersections. The accused device is 6 great circles with 60 intersections, so no literal infringement. The question is whether it's infringement on the Doctrine of Equivalents, and the asserted defense to the Doctrine of Equivalents here is that essentially the accused device is the same as the prior art, or at least close enough to the prior art such that it's not appropriate to allow the Doctrine of Equivalents to cover it, right? And so the court holds in Wilson Sporting Goods it is a matter of law there cannot be infringement under the Doctrine of Equivalents, right? The court says, and you can see the excerpt right here, the answer is that a patentee should not be able to obtain under the Doctrine of Equivalents coverage which he could not have lawfully have obtained from the PTO by literal claims. The Doctrine of Equivalents exists to prevent a fraud on a patent, citing Graver Tank, not to give a patentee something which he could not lawfully have obtained from the PTO had he tried. Thus, since prior art always limits what an inventor could have claimed, it limits the range of permissible equivalence of a claim. Right? So it is, of course, as an aside, ironic that the court cites Graver Tank for this particular proposition, since, as you may recall in Graver Tank, the patentee there was actually able to, although it's not clear that the Supreme Court realized it at the time, the patentee was actually able to gain coverage over something they tried to claim but was rejected by the Patent Office. But in any event, the court sets out the basic rule, which I explained a little earlier, which is you cannot use the Doctrine of Equivalence to obtain coverage of subject matter which you could not have just claimed validly as part of your patent claim, right? But here's the thing that's interesting about Wilson Sporting Goods, right? Which is the court notes that the accused golf balls were actually not in the public domain. They actually differ from the prior art. And so it's not the case that the patentee here was simply, or that the patentee here was trying to use the Doctrine of Equivalence to cover the prior art. That is not what was happening. What was happening is that the patentee was asserting equivalence over something that was not in the prior art, but somewhat similar to the prior art. And so, in fact, if you unpack the Wilson Sporting Goods concept, it's actually broader than you might think, because it's not merely that you can't claim equivalence over the prior art. You can't, what it actually means, and what I think Wilson Sporting Goods stands for, is that you can't assert equivalence over unpatentable variations of the prior art, meaning exactly the prior art because of 102, but also those things which are obvious in light of the prior art under 103. Right? And again, the reason for this is relatively straightforward, and it's right there in the excerpt that I've provided, which is the patentee should not be able to obtain anything under the DOE that they couldn't have obtained by claiming. And if you couldn't have obtained an obvious variant of the prior art in your initial claims, then you can't get it later through the assertion of the Doctrine of Equivalence. So although Wilson Sporting Goods seems to couch it merely in terms of you can't practice the prior art, I think the concept is significantly broader. So one of the other interesting things about Wilson Sporting Goods is it actually offers a suggestion to courts of how you might analyze this particular idea of practicing the prior art as a defense to the Doctrine of Equivalence. And here's what they say. Whether prior art restricts the range of equivalence of what is literally claimed can be a difficult question. To simplify analysis, it may be helpful to conceptualize the limitation on this equivalence by visualizing a hypothetical patent claim sufficient in scope to literally cover the accused product. The pertinent question then becomes whether that hypothetical claim could have been allowed by the PTO over the prior art. If not, then it would be improper to permit the patentee to obtain that coverage in an infringement suit under the Doctrine of Equivalence. If the hypothetical claim could have been allowed, then prior art is not a bar to infringement under the Doctrine of Equivalents. Viewing the issue in this manner allows the use of traditional patentability rules and permits a more precise analysis than determining whether an accused product, which has no claim limitations on which to focus, would have been obvious in view of the prior art. So what the court is saying is maybe one way to analyze this is to construct this hypothetical claim. And the hypothetical claim would be one that directly covers the accused infringing product, and then you analyze that hypothetical claim trying to determine whether or not it's patentable. If it's patentable, then prior art isn't a limit on the DOE. There might be other limits on the DOE, of course, but prior art is not. On the other hand, if you find that that claim would be unpatentable, right, that hypothetical claim is unpatentable, then the Doctrine of Equivalence assertion cannot stand either. So looking back at the example I gave you a few minutes ago, let's consider we have a square-headed stainless steel bolt with a nut, right? That's our claim. Square-headed stainless steel bolt and a corresponding nut. We want to assert infringement over, let's say that final example, brass square-headed bolts and nuts, right? So what we would do is we would alter our claim, alter claim 1 to change the word stainless steel, right, to brass. Right? Instead of the stainless steel limitation, we'd include the brass limitation. So we'd rewrite our claim, and then we would analyze that under the hypothetical claim analysis to determine whether it was patentable. And the question would be, is it patentable over the brass hex-headed bolts and nuts that are in the prior art? And the answer is, I don't know. I mean, it sounds obvious to me, but that would be the test, right? If it was obvious, then you can't get it. You can't use the Doctrine of Equivalence to do it. Now, one of the challenges that's been presented by this hypothetical claim analysis is that sometimes parties will play fast and loose with it, right? And what they will do is when they rewrite their claim as a hypothetical claim, they will sometimes include additional limitations in order to avoid, for example, prior art, right? So let's say, for example, that in this example, I change stainless steel to brass, and then when I say a corresponding nut, I say a corresponding square nut because that's what the accused infringing product has, right? That may allow me to get further away from the prior art brass hex-headed bolts and nuts, but that's impermissible, and the Federal Circuit has struggled with this some, but that's impermissible because you're changing aspects of your claim in making a hypothetical claim that is much more narrow in important respects than what you actually are asserting with respect to the Doctrine of Equivalence. So you have to be careful with this hypothetical claim analysis that what you're doing is only altering those claim elements or claim limitations that you're using the Doctrine of Equivalence coverage for, and not adding new limitations or otherwise affecting the scope of the claim. But otherwise, it's an interesting way to think about what we mean by saying prior art limits the scope of the Doctrine of Equivalence, right? And so in general, I think it's probably a helpful way to analyze these issues, although as I've noted, there has been a tendency of parties to try and play around with this analysis, particularly patentees, to try and, in a sense, game the system. Next, let's consider the case of disclosed but unclaimed subject matter. Sometimes you'll also see this referred to as the public dedication rule or the disclosure dedication rule. It comes by a bunch of different names. The basic idea here is that if you disclose subject matter but do not claim subject matter, you can't use the Doctrine of Equivalence to try and recover that subject matter. And so the main case here is Johnson & Johnson versus RE Services. And the question is, what did the patentee do here to lose Doctrine of Equivalence coverage? The claim here is for the use of a substrate sheet of foil during semiconductor manufacturing. The claim is directed to an aluminum substrate sheet only. All right? The specification says aluminum is preferred, but lists a number of other possible sheets that you could use, a number of other possible metals you could use as the substrate sheet. For example, stainless steel, nickel, and polypropylene. RE Services, the defendant here, uses a steel backing sheet. So obviously there's no literal infringement. Why? Well, the claim says it needs an aluminum substrate sheet. So the question is really one of the doctrine of equivalence. Is a steel substrate sheet in this context equivalent to an aluminum, to the claimed aluminum substrate sheet? At first glance, you might think yes, and the jury indeed found that there was doctrine of equivalence infringement here. So the issue here, however, is that the court holds that because Johnson & Johnson, when they wrote their specification, disclosed steel, but didn't claim steel as the substrate sheet, no doctrine of equivalence is available to cover the steel, right? So because of that, they could assert other kinds of equivalence or other types of materials as equivalent, but they could not assert equivalence over materials which were disclosed in their patent specification and not claimed. And so why would we have such a rule, I think, is something of an interesting question. So there's a few possible reasons, right? One is maybe this is all about public notice, right? That this is a clear case of trying to reconcile the doctrine of equivalence with notice to the public about exactly what the patent does and doesn't cover. And if you say in your specification that a variety of materials are okay, that can be used with your invention, but then you only claim one such material, the public is entitled to rely upon your assertion and your obvious implication that you're only claiming one material, and you shouldn't be able to use the doctrine of equivalence to cover materials that you didn't. Another reason to have such a rule is to try and enhance the Patent Office proceedings. The Patent Office obviously only considered the patentability of the claim with the aluminum substrate. They didn't consider the patentability of claims with steel substrates or polypropylene or any of the other possibilities that Johnson & Johnson disclosed. And so for that reason, to uphold, in a sense, the integrity of the PTO process, maybe you need to have a rule that prevents patentees from being able to further expand the scope of their coverage beyond what the PTO considered in any way, and indeed explicitly did not consider, right? And finally, this is another possible way, another way that the Federal Circuit has managed to limit the scope of the doctrine of equivalence. Here in Johnson & Johnson, the case was relatively straightforward because they were pretty clearly disclosed steel as one of the substrates and didn't claim it. The cases can be closer. There can be cases out there where it is ambiguous as to whether you disclosed a particular embodiment or not, or perhaps you disclosed the embodiment but didn't say much about it or something like that. And I think those are tougher cases for the disclosed but unclaimed subject matter. But the idea remains the same, and the idea is that you cannot use the doctrine of equivalence to capture subject matter which you disclose in your patent documents but do not claim. And so to some degree, this rule is particularly a trap for unwary patent prosecutors, right? You need to be very careful prosecuting patents that if you're going to disclose certain kinds of things, you make sure you claim them. One of the possible pernicious effects of this rule, of course, is, as you might imagine, it has one incentive of encouraging patentees to either claim more broadly than they want to, i.e. Johnson & Johnson should have tried to claim more than simply aluminum substrates and had those claims evaluated. Maybe they were not patentable, in which case everybody would have ended up expending more costs, the PTO from prosecution from having to reject those claims, Johnson & Johnson from having to try and push for those claims. Or alternatively, the incentive might be to disclose less, right? So if you only want to claim aluminum, then only disclose aluminum in your specification as one of the options, and then that allows you to later have the option of asserting stainless steel or steel as one of the equivalents. Now, there might be other reasons that steel would not have been a possible equivalent. We don't really know. There might have been prior art out there. There might have been estoppel or other reasons that it wouldn't work. But what we do know is that Johnson & Johnson would have been better off, at least in this context, by disclosing less. And so that's one of the potentially perverse consequences of this kind of rule, which is if you say that people are going to dedicate to the public things that they disclose but don't claim, then the natural follow from that will be that people disclose less to the public. And so, although this rule makes sense at one level, it probably has an effect of discouraging full and complete disclosure. Next, let's consider the doctrine of equivalence and means plus function claim limitations. So you'll recall (35 USC 112F) used to be 112 paragraph 6. Now it's 112F. Specifies that you are able as a patentee to claim elements in your claim as a means or step for performing a function without reciting structure, using what we now know, what we understand generally to be known as the means plus function format. And such claims shall be construed to cover the corresponding structure, material, acts described in the specification and equivalence thereof. So the interesting thing about the way that 112.6 works, of course, is that it is, or 112F, is that unlike most other types of claim language, it's expressed in the statute that the way you interpret 112F claim elements is by utilizing the specification and looking for the corresponding structure, the structure that corresponds to the particular equivalent in question, or the particular claim element in question, the function, and incorporating that into the claim language, and essentially that determines your scope of that claim element. The interesting thing, and we've gone over means plus function claims before a few times in the course, but what I want to talk about now, and what's interesting here, is note that 112F actually says that the claim shall be construed, this last clause of the sentence here, such claim shall be construed to cover the corresponding structure, material, or acts described in the specification and equivalence thereof. So this is the only place, as we noted when we discussed Warner-Jenkinson, the only place in the statute that actually expressly refers to the doctrine of equivalence, and it does so in a way that suggests that the interpretation of means plus function claims incorporates a concept of limitations, or of equivalence. And so that raises some interesting questions for how to interpret means plus function claim limitations and analyze the doctrine of equivalence with respect to them. So the case that I had you read is Odetics, right? So Odetics is sort of a key case in this area. It's a 1999 Federal Circuit case. The basic technology here were these large machines that would essentially store videotapes. You can see from the diagram there, the videotape fits into this bin, right? And this bin would then run on a track, a conveyor belt type of operation, and it was sort of an automated storage library for videotapes. It was useful for things like television stations or networks or movie studios, places that had a lot of archival videotapes that they needed to store and to automate the process of retrieving and storing the videotapes, and that's what this system did. So the key claim element here, the claim element that was at issue, was rotary means, right? The key claim element was rotary means. And the specification made clear that the rotary means had essentially three components to it. These bins, right? This bin here, the gear, which achieved rotation, right? There was a gear. You can see that 52 in the diagram there is a motor. That wasn't actually part of the corresponding structure, but the corresponding structure did clearly include the gear, which would press these bins in a circle around the axis. So there are essentially three components to the rotary means element. And so that's what the court found, right? And so in the 151 patent had bins, an axis of rotation, and a gear. This is all part of the rotary means element. The accused device was very similar, but it did not use gears to rotate around the axis. What it used instead was a series of pins, and these pins would sort of hit pieces of, hit particular objects along the track and therefore spin that way by using the rotational force that would happen when you hit these pins that were mounted on the bins. And so they didn't use gears, but they had the bins. They had an axis of rotation, very much the same, but they had pins, right? And so that's the setup here for our analysis. What happened here is that the district court granted, the jury had found that there was a infringement, that the accused device was equivalent to the 151 patent, and the district court entered judgment as a matter of law, saying that the gear was not the same as pins, that gears could not be equivalent to pins, and therefore there could be no equivalence infringement for the Odic's patent, the 151 patent. Now, the interesting issue here is that what the court has to do, what both the district court and the federal circuit have to do in this context, is distinguish between the literal infringement of the 151 patent and the equivalence infringement of the 151 of the possible equivalence infringement of the accused device. And Odic is the sort of one of the key cases of trying to analyze what we mean by equivalence infringement in the context of means plus function claims. Right? So what's the issue here? Well, the issue is that 112 paragraph 6 or 112F says equivalence, right? You remember from the language of the statute, it says that equivalents are included in the construction of the claim, right? So if that's true, if the construction of the claim is bins, axis of rotations, and gear plus the equivalence thereof, then what do we get from DOE equivalence, right? Because this sets up a possible situation where there are in effect two types of equivalence. There's 112F equivalence, those which the statute actually says you get, and then there's DOE equivalence, those which you get as a virtue of a scope of doctrine of equivalence attaching to every claim, not because that's what the statute says, but because that's the way the law has been since the 1850s, right? And so what Odic says is that the district court thought this was a big problem, that they had to analyze this very carefully and not offer significant equivalence. What Odic says is that they're not really the same, is that 112.6 equivalence and DOE equivalence are not in effect the same. And the way that it analyzes this is it says the way that you consider equivalence is to look for an equivalent function, an equivalent way, an equivalent result, right? And what the court says is the function of a 112.6 or a 112F claim element is that function, is literally that function which is described in the claim, right? So here, rotary means. So what is the function? The function is rotation, or rotary function, right? And so that's the function. And so in order to achieve infringement of the 112, literal infringement of that claim element, the accused infringing device, Odic says, has to have that function, a rotary function, and at least an equivalent way of achieving it and an equivalent result. That's what, for the Odetics court, 112F, 112.6 actually means when it says equivalence thereof. It doesn't mean equivalent function, equivalent way, result. It means same function, an equivalent way, and equivalent result. Using an equivalent structure, and does that structure achieve the same function in a similar way or equivalent way and reach an equivalent result? That's the key question. And so then, if that's not true, you still then have a scope of regular doctrine of equivalence infringement, and what that means is you get to relax the requirement for identical function, right? So instead of having the same function, the rotary function, you could potentially have an equivalent function. Now, I'm not sure what an equivalent function to rotary might be, maybe circular or something like that. Wasn't at issue in that case. But the way the court sets up the analysis, it tries to analyze this in a way that prevents a conflict between 112F equivalence and DOE equivalence, because what the court doesn't want to allow is equivalence of equivalence, right? You can understand that would get extremely nebulous and difficult to determine. Right, so the court says the way that you analyze 112F, 112.6 equivalence is you look for the same function with an equivalent way and equivalent result in the structure. Right? The way you analyze doctrine of equivalence infringement for a means plus function claim is you look for an equivalent function, an equivalent way, and equivalent result. Because of that, these aren't quite the same analyses, but they're very close. The court reverses the district court's judgment as a matter of law that we noted before on the gear versus pins, because this analysis, the court says, was impermissible, right? Because although we go element by element, right, we have an all elements rule, every claim element has to be analyzed separately and an equivalence associated with each claim element. What that does not mean, the court says, is that you use each component of the claim element. Remember that these three components, although I've lined them up in a way that might suggest that they are individual claim elements, they're not. What they are is pieces of structure related to one claim element, the rotary means element. And what the court in Odic says is you can't subdivide, you can't further parse, right? So just because the 151 patent described three pieces of structure that achieve the function doesn't mean that each piece of structure disclosed has to itself be analyzed on an individual basis. Instead, the court says what you do is you analyze the entire structure. Here, the bins, the axis of rotation, and the gear. You analyze that structure as a whole with whatever the accused device has as structure. Right? And so that it's impermissible to do what the district court did and go component by component of structure, that components of structure are not claim limitations, the function itself is the relevant claim limitation, and the corresponding structure as a whole is part of that claim limitation, but the individual components of that corresponding structure are not claim limitations. Right? And so that was the rule of Odetics. Now, there's a couple of ways. There's another case out there, the Chuminata case, which also deals with this type of 112.6 equivalence and doctrine of equivalence. And Chuminata does this a slightly different way. Right? Chuminata takes more of a temporal aspect. Right? So for literal infringement, right, you need structural and functional identity. Odetics is the same. Right? This is just the standard literal infringement we've gone through for the whole course so far. 112.6 or 112F equivalence, what Chuminata says is pre-existing structural equivalents are available under 112.6. And then Chuminata says after arising structural equivalents are available under the doctrine of equivalence. Right? So the court says there's no overlap of equivalence because they arise, they have different temporal aspects, and that whatever's pre-existing is analyzed under 112F, whatever's after arising is analyzed under DOE, but otherwise the analysis is essentially the same. Odetics takes a different cut at it and says that what matters is for 112.6 equivalence, you still have to have the identical function, but you can have structure, equivalent structure, that achieves the same way, the same function in a similar way with a similar result. And then under DOE, you get a slightly expanded version of the function. You can go to equivalent function, right, as I just explained a minute ago. And so I just wanted to flag this for you. I think, Odetics has probably the majority of the sites, but you will see Chuminata cited on occasion, and it's interesting as a jurisprudential matter to note that the Federal Circuit has not really settled itself on one of these two forms of analysis. Finally, let's talk about the reverse doctrine of equivalence. The reverse doctrine of equivalence is an interesting topic, although one that's largely been confined in its discussion to academic circles. As you'll see, the Federal Circuit has never actually found the reverse doctrine of equivalence. The reverse doctrine of equivalence comes from the Westinghouse case that I gave you to read. And the Westinghouse case stands for the proposition that even if literal infringement can be found, if the accused device is so far changed from the principle of the device so that the literal claims do not represent the actual invention, then there can be no infringement. Right? And you can, so the technology here was air brakes, and basically what the court thought was that although the accused defendant, Boyden, had probably literally included in his device this auxiliary valve, which was sort of the key claim limitation. The way that his device worked was so different, and in fact the court thought quite novel compared to what was described in the patent, that it thought it was simply incorrect or unfair to allow this to be determined to be infringement. Right? This on page 885 of the excerpt I gave you, I guess the fourth page of the excerpt, about halfway down you can see the key language here. So the court says, but even if it can be conceded that the Boyden device corresponds with the letter of the Westinghouse claims, that does not settle conclusively the question of infringement. We've repeatedly held that a charge of infringement is sometimes made out, though the letter of the claims can be avoided. Right? That's the doctrine of equivalence. The converse is equally true. The patentee may bring the defendant within the letter of his claims, but if the latter has so far changed the principle of the device that the claims of the patent, literally construed, have ceased to represent his actual invention, he is as little subject to be adjudged as an infringer as one who has violated the letter of a statute has to be convicted when he has done nothing in conflict with its spirit and intent. Right? So the court sets up this doctrine of essentially the reverse doctrine of equivalence, which is even if you literally infringe, if your invention is not equivalent, then you don't infringe. All right? Now, there's a big question about whether this still has a lot of bite in modern law. Right? The Section 112 in particular, that requires you to describe your actual invention in detail, has in effect narrowed the scope of claims in a way that, at least in my view, makes the reverse doctrine of equivalence not as meaningful anymore. And that's why, if you propose a claim construction that doesn't represent your actual invention, right? So if you are claiming something is incorporated within the literal scope of your claim that is not your actual invention in the terms of Westinghouse, then I think that's an invalid patent. That's a patent that is not fully described, right? Or at least your interpretation of the patent claim is invalid under Section 112, right? So if that's the case, then we should ask ourselves whether we really need the reverse doctrine of equivalence. And the Federal Circuit indeed has never found the doctrine of equivalence, and indeed has in 2002 expressed its view that since 112 was enacted, and that there really isn't much of a need and no real call for the reverse doctrine of equivalence. Now, Academics and scholars talk a lot about reverse doctrinal equivalence because, in theory at least, it could impose a significant limitation on the scope of patents, particularly patents that were being asserted in a way that was overbroad given their literal scope. But then again, the Federal Circuit has never found reverse doctrinal equivalence, so it's not clear how important it is. But I did want to show you how it operated, just to flag it for you. It's an issue that does bubble up every now and again. Whether or not it will actually attract attention in litigation is fairly unlikely. Again, I think most of the issues surrounding the reverse doctrinal equivalence are typically resolved in modern patent analysis through 112. But it is a doctrine that the Supreme Court has said is out there, and it's never been expressly overruled, although there have been statutory changes that might have that impact subsequent to the Westinghouse case. But in any event, that's what the reverse doctrinal equivalence is, right? The basic principle that even if you literally infringe, if the accused device is essentially not equivalent to the patented invention, then there will be no infringement. And that's the end of Lecture 16, and I'll see you next time.